Hello YouTube, I'm Vince White. I am an employment attorney, and on this channel we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Because it is after 8 p.m. Eastern Time today, and I'm still making you videos, I have a guest star. In fact, the guest star is Lafroig Kerdias. I don't know how to pronounce either of those words. I hope I got them right. Lafroig Kerdias. Probably I didn't. I think the only qualifications on Lafroig's resume might be being cast in 2018, which I find delightful. Now, back to your question. We have a question here from Mangesh Kulkarni, who asked us, I have a discrimination and retaliation case against a large employer. I have a contingency fee-based attorney, but it seems that attorney is not paying too much attention. My trial date is within 6 months, and discovery was done very lightly by this attorney. During mediation, this attorney wanted to settle down at a very small amount, around 10 to 15% of what we had originally asked for after only 4 hours in the mediation. Concerning, I decided to walk out. I decided to walk out due to this lowball offer from my ex-employer. My case is strong, as almost every law firm and attorney want to take it on a contingent basis. I was terminated after filing with the EEOC within about 6 months, and went through a very difficult time due to my supervisor's racist behavior. It seems to me that this law firm didn't invest too much, thus was willing to settle down for less. What should I do apart from looking for another law firm? This law firm already has a contract with me. Okay. Mangesh, I'm going to make a suggestion for your first step. Please understand, it's just something I'm getting out of the way. I suspect this is not a useful step for you. I suspect you have a strong and well-defined idea of the valuation of your claims. But because I'm making this video for everyone and not just you, I'm always going to recommend the first step is when you're at odds with your law firm, your representation as to the valuation of your case, go ahead and grab our playlist on how to calculate damages and watch the whole thing. Not because I want views, but because I want to kind of address the idea that the strength of your case doesn't have as much to do with the valuation of your case as you might think. Remember that damages in this field are bifurcated. You have two parts to your case. Whether or not your case wins, the liability part of your case, and what your case is worth, the damages. And you have to calculate those damages, and then you hedge for risk by looking at the liability, right? So if you say, oh, I've got a $100,000 case, just for ease of math, you can call it $1 million case. I don't care either way. So let's call it $1 million case. I got a $1 million case, but if I think I win it only 7 out of 10 times if I run that trial 10 times. Okay, so you might want to hedge for risk and say to yourself, it's $1 million case. I win it 70% of the time. Maybe I want to settle around the 70% mark. Just super loose, kind of silly math. Silly in terms of the simplicity of it, right? These are just thought experiments, not actual guidance. Now, once you look at the damages component and you determine that, in fact, you are correctly calculating the damages in your case, the second thing to do is look at the liability portion of your case and say, hey, am I confident this wins? And how often do I think this wins at trial? Seems like you're very confident there, and that's meaningful. It is. So, if your damages are correctly calculated and you feel very confident in the likelihood your case wins, now you can start to turn to what your counsel is doing, what your representation is doing, with a more fully informed and like skeptical eye, right? Now, there are a lot of firms in the world. I have videos about them. They flip cases. It's very easy to flip a case and make a lot of money with almost no work. The problem is you don't maximize the value of the case for your client. Now, there's certainly clients that are happy with that, right? There's a lot of people who come in who want 20 grand, and it's fairly easy for an attorney to probably get them that 20 grand in about 2 hours of work. And if that attorney's not a 40% contingency, well, that attorney just made about 8 grand, 2 hours, so $4,000 an hour. The attorney's happy, and if the client's happy, I'm fine with that. The problem comes in when the client's not happy, and the attorneys are trying to get the client to take that 20 grand or whatever the 10 to 15% was on your case, right? It's about I'm not saying that your 10 to 15% is 20 grand. What I'm saying is it represents the same meaningful number. in the sense that in either case, it's inadequate. It's not enough. It's not what you want from this case. It's not going to make you feel whole. It's not going to be what you think is rightfully yours. It's not going to be how you calculate the damages. And it's not going to be how you hedge for risk. No logic that you're employing is going to get you that 10 to 15% number this attorney's trying to get you to take. So, why? The third step I'd recommend is you go to the attorney and you say, why? Why would I take 10 to 15%? Tell me. In depth. I want to hear all of it. Maybe tell me in writing. I want to know, line by line, what is your logic? Why would I take what you told me to take at that mediation? Why? And then listen. Listen completely. Like, really hear them out. And I would actually say, take notes. Let them give all the reasons. Let them list off the risks. Let them give you their rationale for taking 10 to 15% of what you had originally demanded. I would love to hear that. And then take your notes and you say, okay, I'll get back to you. And go home. And go on this channel and list off what they said. With some specificity. And I will make you the world's longest video, going line by line, kind of discussing each risk that they lay out, how realistic it is, what they're saying about it. Does that make sense? Obviously, I don't know your case. I don't know the facts of your case. I don't know your situation. I don't know what's going on. But if you give me specificity and you're honest, for your own sake, not for mine, I don't care. This doesn't benefit me in any way, really. So if you're honest for your own sake, I will try to deal with each component part that you're going through as an exercise that will benefit you, I hope, directly, but also will benefit people on this channel, not because they have the same situation as you, but because the way we'll talk about and think about your risk could have value in how they will talk about and think about their risk on their case. And I think that could help some people. So go through the steps. Let's do it. And if the ultimate answer is that they're full of it and they're trying to flip your case, then I have videos on how to potentially sever that relationship and find new counsel, how to do it with the least friction and the least litigation and the least anger, right? And also the least financial loss to yourself. So I can give you those videos, or if need be, we'll make you a new video. Either way, the important thing here is that you get the answers you need, and if the attorney you hired won't give them to you, we'll do our best. And if you have trouble, if for whatever reason you're posting your question, you're not getting a response, feel free to email me. Identify yourself. Identify that I said I would help you. Or you can text our firm and ask for Victoria. And she's our firm administrator, and she has a lot of sway and control over the YouTube channel. And you can tell her that, hey, I said that I would do some specific video about your situation. And don't share identifying characteristics, obviously, about your situation with us. But when you're sharing, the details of your case, keep them generic, but keep them as accurate and as specific as possible so that I can address them without putting you at risk. Okay? I hope that's helpful. I'm sorry you're in this situation. Sounds like you have a strong case. I'm sorry about the racism. I know it's ever present, but I'm sorry that it got really bad for you. And I hope it can help in some way. Speaking of which, if this video was helpful, like, subscribe, comment down below. It helps us to help more people just like you. Remember, everybody works, but not everybody wins. Not everybody gets to stop working at 5 p.m.